go into session for the November 5th, 2015 meeting of the Radnor Township Zoning Hearing Board. Our first item, please stand and join me in the Pledge of Allegiance. Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. We have two items on the agenda this evening. The first item is Appeal 2956, 1122 County Line Road. The applicant, I Lead Inc., property located at 1122 County Line Road and zoned R5, seeks a special exception from Code Sections 280-101A and 280-101A1 to continue the nonconforming use of the prior occupant. Welcome. If you could give your name and address to the stenographer, and she will swear you in.
Sure. My name is David Castro. I live at 115 Peachtree Avenue, Bryn Mawr, 19010.
Okay, raise your right hand. Did you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, nothing but the truth?
I do.
And spell your name and your street, please.
Sure. It's David Castro, C-A-S-T-R-O. The street is Peachtree Avenue, P-E-T-R-I-E, 115.
Mr. Castro, please proceed.
Thank you very much. Yes, we're appearing. I'm the president and chief executive officer of the nonprofit corporation. It's called I Lead Inc. And we're requesting that the non-conforming use that was in this property before be continued in our use. The property, the tenant that was there before, my understanding was the Blue and White Foundation. It's a scholarship foundation that supports students at Villanova University. We are a small nonprofit organization intending to use the property in a very similar way, that is for just administrative use with a small number of employees, 3 or 4. I believe that we've submitted the, with the application, a visual of the parking lot. There would be 4 parking spaces that would be made available for our staff that were there. The lot is large enough to accommodate other users of the property, and I believe it would be a very low impact on the neighborhood and virtually identical in terms of use to what was there before, essentially the administrative use of a small nonprofit.
Mr. Castro, the prior use, the Scholarship Foundation for Villanova, how many employees did they have on the site?
I believe they, again, maybe had 3 or 4 employees. It is a very small office. It's about 1,200 square feet. It has 4 rooms and 1 bathroom. And again, yeah, so that would be essentially our similar footprint there.
Okay, and what is your use, more precisely than administrative offices? What do you do?
Sure. So we are a school for community leadership development, and we do leadership development in low-income neighborhoods all over southeastern Pennsylvania. But our primary relationship is with Harcum College. So we have a huge program that we run with Harcum College on their campus, and also with community-based organizations in the region. We also have a charter school that we operate in Reading, Pennsylvania, and we have a very large facility there. So this is really just for back office support, nothing more than that. We will have at the location our director of development and my executive assistant and me, and that's pretty much it, possibly an intern from time to time.
So you're not going to have visitors and so forth. Can you establish for us how this use became non-conforming?
I can't. I don't know the history of the property. I do know that the way it was explained to me by the landlord and the folks that leased it to us was that this action was required in order for us to get there, that we would have to get the exception continued, in essence, that was there before. So I don't know. I happen to actually live around the corner from the property. I live on Peachtree Avenue, which is literally right around the corner. So I can tell you that Blue and White Foundation was there for a long time. I think maybe as much as 10 years it could have been there. I'm not sure exactly when it was established, but as in my memory, I can't remember what else was there before that.
Can you testify? Can you testify to your knowledge that the blue and white use was being made before February 25th, 1974?
No, I haven't lived in the property I haven't lived on Peachtree Avenue that long, so I couldn't take you back to 1974.
So that's when this zoning code was enacted.
Right.
And for that to be a lawful non-conforming use, it would have to be the use that was made prior to that date, at the very least. It's possible that the prior code also didn't permit this in this district, but putting that aside for a second, it's your burden to establish that they were making this use prior to that date. Therefore, it was a lawful non-conforming use that predated the zoning. And then all you have to do is seek a special exception to extend it to you as a new non-residential occupant of the space. But absent that, you can't establish that it's a lawful non-conforming use, so you don't have the rights under 280-101A, A1. That's the issue. So you need to get something on the record.
Well, let's. So are you saying that you believe that their use was not lawful?
No, I'm saying that you have to come forward with the evidence
Yeah.
and bear the burden of proof that that use was lawfully made as of that date or before in order to qualify for the special exception. Otherwise, what you need to be asking us for is a variance, which is a higher standard.
And which has not been advertised.
And that has not been advertised yet.
But there's no change in the non-conforming use here.
Right.
We agreed on that?
But a non-conforming use is defined in our code as being one that was lawful prior to the passage of the law that says you can't make that use. Otherwise, it doesn't meet the definition of a non-conforming use.
I think that whether it's a change in the use that would be covered by special exception, if it is non-conforming, I think so. I'm not sure that this case is the same as the church case where it was a daycare center, the same use being used under a different ownership. I think that there are differences that would warrant the special exception, but we need something on the record to show that the underlying use was lawfully non-conforming in order to give the special exception for the new use.
So you're asking them to prove a negative here?
No,
A positive. They need to come and say.
That it was not illegal use.
No, they have to prove that
The use.
this use was in effect before this code said you can't do it at that property.
To prove
It's a
that
positive. So if they, for instance, had someone from Blue and White to come in and say, yes, we were making this use as of this date and before,
Let's-
or the landlord, if he were the landlord, then could
Yeah.
testify.
I think the land.
Kevin, is there anything in the township's files that shed any lights on this question?
Without getting into a detailed review of those, I'm not sure. As far as I know, Blue and White has been there for a number of years, but I couldn't put a specific date to that.
Yeah, I also am not certain when their use began. I don't know how long it was there, and I don't know if I can get them here. Yeah.
Talk to us a little bit about your, the practical circumstances currently, in the sense that, are you using it? Are you
No,
scheduled to move in at a certain date?
We have a lease that is contingent upon the use being granted. So in other words, we're awaiting to take possession pending the exception being continued. If the exception was not continued, our lease would probably not become effective. So we're not in there, we're not using the property at present because we wanted to make sure we did it lawfully.
I'm just not following this. You're asking to show that the use before 1974 was a lawful use?
No.
And that whatever that use was, it was similar to what he's doing now? How do you do that?
If the use of the blue and white came in after the date in 74, and essentially they just opened up for business and started doing this, and never secured any relief from the zoning board. They, for these number of years, have been operating illegally because it's in a residential zone, and they never secured any relief to do that. If, to the contrary, they could demonstrate.
Do we know they never secured any relief to do that?
It's the applicant's burden to show that they did or didn't need to. If it went back then, it's not our burden to say he's not entitled to it. We have no stake in the matter except to enforce the code. It's his burden to show that, let's say, for instance, when the ordinance was passed, this was a residence. And let's say 5 years later it was converted and Blue and White moved in. And Blue and White just moved in and somehow got away with it, and now he's going to do the same use. That's not a non-conforming use under the definition, either in Section 101 or in the definition section of the code, because it has to have been lawful before the code changed to make it unlawful.
So let's say it's an illegal use right now. He wants to have a legal, non-conforming use, so he asks for a special exception.
Well, it has to be non-conforming. It's not. If it's not, let's say Blue and White wasn't operating back then.
Right.
It was different. Then he's got to come in and say, I'd like a variance to do this in the property because the code doesn't let me do this otherwise.
Would you be willing to ask for a variance?
Well, let me suggest.
Am I able to
step.
amend my request to
Well,
seek
no.
a variance?
No, because
Go
of,
back to square one?
Because of advertising issues,
Yeah, I see.
that's a concern. Let me suggest a practical resolution, and John or Kevin can tell me if advertising or other technicalities would cause this to be a problem. I'd like to, in essence, table this and see if we can put it on the calendar for the regular November hearing 2 weeks from Thursday, put it on the front of the agenda, and you would have to bring in something in the character of a witness or an affidavit that would talk about how long the Blue and White use goes back.
So let me just ask, if I could just ask a question, if we can establish that their use was before 1974, then you're saying that I need a variance?
Yeah, well, also,
Yeah.
we know the zoning code changed in '74. We actually need to know that the use commenced legally at some point in the past. Now, we know that as of 1974, it was illegal. It may be earlier that the problem came. I mean, I would strongly recommend that you get counsel to, walk you through this and make the burden, because otherwise, from what we've heard so far,
So you don't think there was ever an exception granted to the Blue
we
and
don't
White
know.
Foundation? I see.
We just don't know
I see.
on this
To
record.
be clear, he doesn't have to worry about any of that if he asks for a variance.
He asked for a variance.
He doesn't have to worry about the history.
Except that he then has to have, it's a use variance, and it has to be re-advertised. Just to let you know.
Well, let's talk about that. If a special exception was advertised,
Yes.
you can't ask for a variance
No,
now?
you
Which
may
is
not.
lower standard?
No. And just to make this clear, I've said it before, the Pennsylvania Supreme Court has issued a line of cases in the last 10 years that really require the advertising to be precise. And if it's not precise, then the decision of the zoning board is challengeable for an unlimited duration. Normally, to challenge it, a person has to appear in opposition, and after the decision is rendered, they have 30 days, and then once it's, the 30 days is expired, if the decision was improper, too bad. It's 30 days, and no appeal has been filed, you're home free. But for publication errors, and this would be of that sort, it's open for anybody to challenge it forever, and that's the reason that we are, we have to square the corners on advertising. That's
I see.
it's not you. It's not we
Right.
want to be difficult. It's that the body of law that the Pennsylvania Supreme Court has announced requires us to do that.
So basically, I've got to prove that the property was being used in a way that was non-conforming before 1974, or I have to ask for a variance.
Yeah.
Even if they were there for 20 years, it wouldn't matter. Yeah.
Actually, you have to prove that.
Yeah.
And let me make it
Yeah.
clear. A non-conforming use is a legal use because the municipality is not allowed to change the rules on somebody and then say, aha, you've got to shut down, okay? Pennsylvania law
Right.
protects non-conforming use. If your use was, if the zoning prior to 1974 permitted your use, then there's an enactment of the zoning ordinance couldn't shut you down unless the use had been abandoned or something like that. But what we need to know is not 1974, but at least, it's at least as far back as 74 and maybe earlier, okay? We need to know that when the office use, administrative offices commenced on the property, be that 1974 or 54 or whatever, it was permitted under the zoning code, okay? And if it goes back prior to 1928, it's, per se permitted because we had no zoning prior to 1928. But you have to, when the use commenced, when the office use commenced, it had to be lawful under the zoning code. If you can show that, then the subsequent change of the use, you're grandfathered against the subsequent change of the use, and provided the use wasn't abandoned or something like that, you're able to apply for the special exception. But personally, I think you need counsel on this.
So you'd have to show a continuous
Continuous use.
in the same party also, so basically.
Not
it's
the same party
Not necessarily the
necessarily.
same party.
You'd have to have
just-
special exceptions for changes in the nature of the use. I've advised this board that your use is sufficiently different from the prior use, so it probably needs a special exception. We had one case a while ago where the use.
Yeah.
Well, I advised, no, I
right.
advised them, I advised.
It's in the
I did not
ordinance.
decide that.
And the ordinance says,
All right, we're
Made a
going
statement
to,
that the prior use is different than his projected use.
Well, I
but
just said I would advise-
that's
I
really not
advised you.
relevant.
I advised
Look,
you.
gentlemen, any change in non-residential occupancy, which we have here, shall be deemed to be a change of use for the purposes of 101A. So the fact that it's a non-residential occupancy, the mere change requires them to get the special exception, even if he were doing the exact same use with the exact same number of people, because it's a non-residential occupancy. That's right in the ordinance.
Yeah.
So, Mr. Castro, I think if you asked us to press forward to bring closure to this matter tonight, it may not turn out the way you want it to turn out.
Right.
So what I am suggesting is that we postpone further consideration of this, and I'll ask that question one more time. Are there any technical impediments to having it heard at the meeting 2 weeks from Thursday?
No, there are not.
Well, not, if it's a variance case, there is, because it
No,
won't be
no,
advertised.
I understand.
As a
Yeah,
special
if it's a
exception.
That-
variance, if it turns out you need a variance, then we would have to re-advertise. We
Right,
would
so-
not need to advertise.
So the first point is this issue of how far back it
Right.
goes and whether you can establish whether it was legal at the time it started. You'll have to take into consideration Mr. Ryan's suggestion that you retain counsel. That's something that you personally will have to determine. You probably, either you or your representative, would want to look closely at the file for this property that the township has. If there are there may be some materials in that file that can be helpful in trying to carry your burden when you sit with us in 2 weeks or 16 days. I also think that the determination at the next meeting, I would like to suggest we put it on the front of the agenda because I think we can clear it one way or the other on the 6th, at the meeting on the 19th. And then if it turns out you can't make that showing,
Right.
you're going to have to reapply for the variance. It'll have to be re-advertised, and then you probably are going to be pushed. Would that push him to the January meeting, Kevin, if he doesn't know what he's doing until, say, November 20th?
I believe so, because the deadline may be November 17th.
So you have a strategic decision. You really need a lawyer. okay?
right.
Because one option is to pull the plug on this, apply for a variance now, get on the December agenda. That,
I have
you
to
know.
talk to the landlord about this because
Yeah,
it was, was not our understanding that it was going to be this
Well,
involved. So, yeah, that's okay. I understand though.
It's possible
Yeah.
he owned the building then and could testify to it.
Yeah,
you know?
I think not though. So I'll have to
Okay,
check
so
with him. Yeah,
with that,
that's
we're
okay.
going to
Table it.
table this
Well,
one.
you have to request a continuance, and you have to give us an extension of time to hear the case, and then an extension of the 45-day period for rendering decision to run not from tonight, but from when we come back again for the next hearing, if you will request that.
So I should file a request for
You
a
should right now
continuance?
tell us
Say
that
it.
you're
Oh,
requesting
say
a
it. Just say it.
continuance.
Okay, I'd like to request a continuance then, yes.
Okay.
And you grant us the extension.
And grant,
To a
and
date
to
certain.
request that you be granted the extension, yes,
And
also.
we're going to continue it till the 19th?
To continue to the regular November meeting, which is on the
19th.
19th.
Okay.
Any objection, the other board members?
And if
Okay.
it turns out that you need a variance, then you would, and you should try to, perhaps with counsel, ascertain that sooner rather than later, then we wouldn't be able to hear a variance request on the 19th because there isn't time to advertise. But there might be time to do it on the December thing if you amend your application or reapply in time for the posting on December. But that is something that you and your counsel or your representative or whatever have to resolve.
I understand. Thank you.
All right.
Thank you.
Thank you for coming out, and presumably we'll see you in a couple weeks.
Thank you.
Okay, the next item on our agenda is Appeal 2957. The applicant, 615 Newtown Road Associates LP, property located at 113 Dovecote Lane and zoned R1. Seek variances from Code Section 280-112D and E for disturbance to and improvement of steep slopes in connection with construction of landscaping features and any other relief deemed necessary. Alternatively, applicant contends that relief is not necessary as the landscape features are permitted on steep slopes and that disturbance to and improvements of man-made slopes is not prohibited.
Mr. Chairman, I would point out that the zoning ordinance, in terms of disturbing man-made slopes, it talks about steep slopes created as a result of compliance with Section 175(11)A and B of the Code of the Township of Radnor. This is basically the grading ordinance, and there have to have been permits. Otherwise, man-made steep slopes from times immemorial that were not actually compliant with this provision require a variance.
Mr. Brosman?
Yes, good evening. I'm George Brosman, representing the applicant, which is 615 Newtown Associates LP. They own the subject property, which is now known as 113 Dovecote Lane. With me this evening is Jim Gorman. He's sitting back there. He is a principal of 615 Newtown Associates LP, and he is going to be living in the new home that has been constructed on this lot. Also with me is Dave Gibbons, who was the civil engineer for the subdivision that created the lot in question, and also is Joe Orsatti. He's the landscape architect that was involved in the original subdivision. I'm going to have Mr. Gibbons testify and possibly Mr. Orsatti. Before I start, just a few opening remarks. This is the old Atterbury Estate property. Mr. Gorman and Alex Waziloff had formed the entity 615 Newtown Associates LP, and they purchased the property and they got a subdivision plan approved for that. We were in front of the zoning hearing board while that plan was pending, I think back in 2012, and we received, it was actually in two separate appeals, but we had received in one appeal a front yard setback relief for the new private road that was built, and we also had received approval to disturb some man-made steep slopes. Basically, we're back this evening because the man-made slopes that we sought approval for, we didn't envision at the time that we would be disturbing these other slopes. So we're back here now in connection with that.
The plans, are they at tab 3 and 4 that show the area of new steep slopes?
The new steep slope,
The area you wish to disturb?
that is on A7 and A8.
Okay. What is the significance of the highlighted thing on A3 and A4?
A3 and A4, I've just highlighted in yellow the general area we're speaking about. We're going to be having testimony that there's an old carriage house and an old roadbed / driveway in that vicinity, and it's going to be our testimony that the band of steep slopes that we're asking to disturb were created in connection with that. And I'll have testimony on that, and some of the other exhibits also show that.
Okay,
If you look at A7, A8 is probably the easier one to see, and I can put a larger one up here.
Can I just suggest you step back and go ahead and present your case perhaps as you planned?
Okay.
And then we may jump in with some of these clarifying questions down the road.
Sure. I wanted to say, because I think some of the board members weren't here in 2012, but this subdivision is, I think, a special subdivision. Mr. Gorman sort of went above and beyond the call of duty on it because he was going to be living there. It's not necessarily relevant to this case, but just so the board can get an idea of the quality of work that was done here. This subdivision has a lot of extra features that were not required by code. It's got Belgian block curb. There are larger street trees that were installed on the private road. There's more replacement trees than were required. Mr. Gorman provided a public trail along Newtown Road. He preserved the view shed along Newtown Road. He's added attractive entrance features. He's added special features at the cul-de-sac. He's got strict architectural controls on the new homes. And he had also deed restricted a part of the property that was actually across Sproul Road and donated that to the Conestoga Swim Club. So in the spirit of that type of development is what Mr. Gorman is trying to complete in his own backyard. What happened is the testimony will show that this property goes back over 100 years, and these steep slopes were created when the driveway that we're going to be talking about was actually Radnor Chester Road that ran through the property. And they were also created in connection with the carriage home is there. We had identified, as I noted to you in Appeal Number 2886 in 2012, during the subdivision process, we had identified certain man-made slopes that we knew that needed to be disturbed. As is normally the case in a subdivision, at that time, the homes that were planned were, I'll call them generic homes, just like typical homes where you would prepare a generic grading plan. So using that information, they came up with the areas of slope that they thought needed to be disturbed. As each lot, as some of the lots have been sold and Mr. Gorman retained this lot, he came up with a specific house design and got a grading permit to build that house. And he also got a landscape contractor and designer to come up with a nice landscaping plan. Since they were not involved in the original subdivision, unfortunately, they weren't sensitive to the fact that there were man-made slopes, and some of the man-made slopes were approved for disturbance, and some had not been. So they were putting in landscape improvements in the rear yard, and the township notified them that they had indeed disturbed some of the man-made slopes that hadn't been approved before. Mr. Gorman immediately ordered his contractors to stop work, and we applied for this relief. So that is what brings us here before you this evening. The testimony will show it's basically a 1,726 square foot area of steep slopes. This exhibit is a larger version of A8, and it's shown here in yellow, right underneath a carriage home. That's my introduction. And with that, I would like to ask that Dave Gibbons be sworn in, and I would call him to testify.
Sir, if you'll raise your right hand, if you do solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, nothing but the truth. And state your full name, please.
Please use the microphones.
David Gibbons.
And for the record, I've handed up to the board an exhibit package which contains exhibits A1 through A10. A1 is just simply a copy of the application that I filed. Dave, at exhibit A2, is this a copy of a brief CV that summarizes your professional qualifications?
It is.
And are you a licensed engineer in the Commonwealth of Pennsylvania?
I am.
And did you testify before the board in connection with the prior relief that was granted for the subdivision of this property?
Yes.
I would offer Dave as an expert in civil engineering.
Please proceed.
And Dave, are you the civil engineer that had handled the subdivision of the former Atterbury tract of which the subdivision of which the subject property is a part?
Yes.
And obviously then you're familiar with the property that's the subject of this application?
I am.
Now, in the exhibit package at Exhibit A3, is this a copy of the existing conditions plan as they were prior to the subdivision?
Yes.
And the area there in yellow is just meant to focus in on the area that's the subject of the application tonight?
Correct.
Now, Exhibit A4, is that a copy of the subdivision plan that was approved?
Yes.
And again, the area in yellow that's highlighted there is just meant to show the general area we're talking about?
Yes.
Since the approval of this subdivision plan, was the cul-de-sac private street, now known as Dovecote Lane, constructed?
Yes.
And what is the lot that is now known as 113 Dovecote Lane on this plan?
Lot 4.
And can you describe Lot 4?
Sure. Lot 4 is located on the eastern side of the tract. It has frontage and access off of the cul-de-sac for Dovecote Lane, and it also has frontage and existing access off of Newtown Road.
So if we were referring to Exhibit A8, which happens to be a larger version here on the board, Newtown Road is here at the top.
Yes, Newtown Road is at the top of Exhibit A4.
And what's the approximate size of the property?
Roughly 1.5 acres.
And what are the current state of improvements on the lot?
There is an existing new single-family home that was just recently constructed, and there's an existing historic carriage home located on the northern end of the property.
And when the original subdivision plan was approved, did the grading plans that were developed at that time assume a generic house configurations for the different lots?
Yes.
Is that a common practice?
It is. During the subdivision process, we typically don't know the final architecture that will be built on each lot, so we do our best to get a generic footprint that we feel would fit the lots and is close to what will be constructed.
And then when the specific plans are developed, do you then submit a grading permit plan and a building permit plan?
Yes.
Now, based on the information available at the time of the subdivision, did you identify certain areas of man-made steep slopes that would be disturbed in connection with the subdivision?
I did, yes.
And if we flip a little out of order, but Exhibit A10A, which is a copy of the board's decision granting the prior slope relief, Appeal Number 2886, if we flip to the second page, it refers to an exhibit, which in that case was marked A4, but it's attached here as part of Exhibit A10A. And we have a bigger one of that. Is this the, are these, oh, sorry. Are these the areas, we called them at that time, areas A, B, and,
Sorry.
areas A, B, and C that we had brought before the board previously for
Yes.
approval to disturb?
Yes.
Excuse me, that A, that's not used, that's not a road.
I'm sorry, I didn't hear.
I'm sorry, what is that? Is that a road that comes through there with that line coming down with A?
It was the existing road, yes.
It was the existing road, that's not used anymore, though, is it?
Correct.
Okay, got it.
Yeah, that was the remnant, and you'll see on the atlas maps of Radnor Chester
Okay,
Road
got it.
that ran through the old estate. And then it became part of the driveway system for the estate when they built Route 320 Sproul Road. And it's shown on these atlas maps that we have. And a part of the driveway is still there, right, Mr. Gibbons?
Correct.
Now, was it your testimony in Appeal 2886 that the slopes that had been identified at that time were associated with either the carriage house and/or the old road or driveway that extended from Newtown Road through the tract?
Yes.
Now, after the zoning board approval and the subdivision approval, was a specific plan developed for the actual house that was built on Lot 4?
Yes.
And was there a grading permit for that design that was approved by the township engineer?
Yes.
During the construction of the home this summer, did you become aware that the township had issued a stop work order that the construction of some landscape features had extended beyond the extent of the approved grading permit?
Yes, I was.
And did you also discover that the landscaping work that was progressing had impacted more of the man-made slopes associated with the old road and carriage house than had been previously approved in Appeal 2886?
Yes.
After receiving the stop work order, is it your understanding that Mr. Gorman ordered his contractors to stop working, and then we filed this application?
Yes.
Now, jumping to Exhibit A8, the large version of which is here on the desk, does this show in yellow the band of man-made slopes that we're here for this evening?
It does, yes.
And what's the approximate size of that area?
Approximately 1,726 square feet.
And there's some photographs on the board here on a part of Exhibit A8. Can you describe those and relate those generally to the man-made slopes in question?
Yes. It looks like two of the pictures, the top picture and the bottom picture of the three, is generally taken from the south side of the steep slopes, looking up toward the existing carriage home. And the third picture in the middle is looking generally east from approximately where the area, just east of the existing roadbed, looking east of the man-made steep slopes.
Could you point out the carriage house on the diagram? Just.
It's actually right up here.
Oh, okay.
So that would be to the north of the yellow band of slopes?
Just to the north of the yellow band, yes.
And in the photographs, the carriage house is the, I guess you'd call that yellow building?
You had indicated that the area for which relief is being sought is approximately 1,725 square feet. Do you have an estimate of that amount? What percentage of that amount has been disturbed as a result of the work that's already been done?
I would say almost all of it, yes.
And that disturbance, how would you characterize that? That essentially placing earth over top of it?
Yeah, I mean, I would say it's minimal disturbance, basically for the fine grading of the landscape features that were proposed.
Now, in your professional opinion, is this area man-made or naturally occurring?
In my opinion, it's man-made.
And can you explain the basis of that opinion?
Sure, from both visiting the site.
Excuse me, Dave, if you could make sure you're speaking to Mike.
It was on, but the battery light wasn't on. Yeah, it's working. Sorry. In my opinion, it is man-made, and that's from both visiting the site and also reviewing the plans that the man-made slopes were created from the cut of the construction for the old roadbed, and also the placement of fill for leveling off an area for the carriage home.
And drawing your attention to Exhibit A5, there's a summary of various, on the top of the years of various historical atlas maps, starting at 1900, 1913, 1920, 1926, 1937, 1948, and 1961. Could you just very briefly take us through each year and identify if these atlases show the old carriage home and the road and the area of the slopes?
Yes, see it on the screen, but this is the atlas from 1900, and the area we are referring to is highlighted in yellow at the very top center of the page. And in this view, you can actually even see the old roadbed, which was the was old Radnor Chester Road, which ran through the site.
And that's running through, Newtown Road is along here at the top.
Yes.
And Radnor Chester Road was going through from top to bottom.
Right, from the north to south direction, correct.
And
Try and speak up, please.
I think it's dying. It's dead again.
I think you have to get really close to it.
The batteries. It's green now, so I think we're good.
So this is 1913.
That's correct, 1913, and now the yellow highlighted area is in the upper right-hand corner of this atlas sheet, and similarly as in 1900, you can see the solid dark line, which is the old roadbed running through the site.
And the little box is the carriage house.
That's correct.
And now 1920, sort of the same thing.
Almost the same exact map. You can see the carriage house there highlighted in yellow with the old roadbed.
1926.
Almost very similar to
Now
the
with
previous
this, however, we see this other road paralleling.
Right.
Is that essentially what would become Route 320?
Right, Sproul Road. That's correct.
1937.
1937 is a little bit different orientation, but the general area has been highlighted again in yellow. Once again, you can see Sproul Road and the old Radnor Chester Road through the site, and the carriage home is obviously still there.
And then 1948.
In 1948 is slightly different, where we've highlighted in yellow the old roadbed is now shown in a dashed line, which we believe maybe is abandoned, or at that time would be something like a dirt road or something along those lines, because Sproul Road was now being fully utilized.
And the carriage house is still there, obviously.
Correct.
1961.
1961 is actually shown a little bit more better detail, and in this one it clearly shows the carriage home, the other existing buildings that are on the Atterbury property, and they're all shown as dashed lines.
Now, Mr. Nagel had asked about, it was the photograph of Area A on Exhibit A8. The first part of this dashed line leading from Newtown Road to the where the driveway had turned, was that the area of the driveway that appeared in that photograph?
That's correct, yes.
So that was the remnant of the old roadbed.
Right.
Okay. Are these historical atlas maps, in your view, consistent with your opinion that the slopes in question are man-made?
They are, yes.
Now, let's turn to Exhibit A6, which is a series of photographs of the area in question. They have individual letters A through E. Could you briefly describe each of those?
Sure. A is actually a view standing on the old roadbed looking north with the carriage home on the right-hand side.
And even in that photograph, you can see it looks like there's evidence of cuts and the different grade transitions between the drive and the carriage house.
That's correct, and we're referring to the right-hand side of the picture, yes.
Could I ask you to remove that one document that's covering the exhibit below, and give us an idea, for example, the approximate spot from where that photo would have been taken.
So
I
he's
would-
referring to A8 now.
Right, on Exhibit A8, it would generally be, I would say, in this location here, which is just west of the proposed dwelling and south of the carriage home, looking in a northern direction. Carriage home is in this general area.
Okay, photo B.
Photo B is,
It's the rear.
right, that's the rear of the building. So this photo is once again looking from just south of the man-made steep slopes, looking up toward the existing carriage home. Generally just east of our last picture, looking in the same direction.
And these pictures were taken after again, to get oriented, these were taken after the work was done that caused the stop work order?
Yes.
So to give us an idea, that the area that we're talking about granting relief for, here would be sort of underneath the photographer's feet?
Underneath the photographer's feet and also in the dirt area, you can actually see that the grass hasn't grown on it yet, and that's the fine grading that was done in that area. Correct. So moving on to C, we're just moving further east, looking still back up northwest toward the carriage home. And in this one, you can actually see the grading that has been done in that area. And it was mostly just minor fill being placed to support the hardscaping. Moving on to D, we're now moving further east, but we're looking now in a westerly direction. And this view is in between the proposed garage on the left-hand side, and you can see the very edge of the carriage home on your right. So referring to Exhibit A8, we're standing in a general area where the arrow is for the area of disturbance label, looking almost due west. This area looking this way.
So that structure on the left is part of the new home, the back of the garage, correct?
That's correct, and you're almost looking along the area of the man-made steep slopes. So you can kind of see from the picture that it's a very gentle slope, very gentle-looking slope once you are actually out in the field.
Area E, or photo E.
Photo E is almost reverse of the photo we just saw. We're actually now standing now over toward the west, kind of with our back to the old roadbed, looking east. And you can see there, which was the water feature that was constructed in the general area on Exhibit A8 of where the arrow is for the area of disturbance.
Now, most of that water feature was not on steep slopes, is that correct?
That's correct. Just the very northern edge of it was, yes.
Just maybe the last couple of stones?
Just the back area, correct.
And then there was, the photo shows, you can see where the dirt is, just some fill to make the transition grade back to tie into the other part of the man-made slope.
That's correct.
That might be the last photo.
Yes.
And did you prepare a plan that shows the partially completed as well as the finished proposed landscaping and other work that Mr. Gorman desires to complete?
I did, yes.
And is that Exhibit A7?
Yes.
We're going to put a larger one here on the desk. So, for the record, is the band of slopes in question that's sort of in the red hatching here?
That's correct.
And referring to this exhibit, can you describe, what would be done to finish the landscaping work that had been started?
Sure. The remaining work is really just the placement of the last bit of landscaping that's proposed, where there's some trees and some shrubs that are placed in the general area here shown just along the red hatching of the steep slopes. And what's also is difficult to see on here, but there's also just the minor fine grading that's associated with the placement of the landscaping and vegetation. We'll also be just extending the pavement down from the carriage home slightly and creating a little small area to do for a turnaround.
Adjacent to the new garage.
That's correct. It just touches the area that was graded already for the steep slopes.
Now, this also shows you have that landscape feature that we talked about overlaid on here. Is that correct?
That's correct.
And where I'm pointing is, it's what we talked about before, that just a couple of the stones had encroached on the steep slopes.
That's correct, along the southern edge, yes.
So the work then was just the, what I would call some minor filling, and then he would like to complete the grading and add a good amount of landscaping on there, correct?
That's correct.
And that whole area, that is, do you have the size? I think we testified to it, but is the size on here?
1,726 square feet.
Now, if the board were inclined to grant the relief for this, will this work be added to an amended grading permit application to be reviewed by and subject to approval by the township engineer?
Yes.
And would the applicant agree to accept that as a condition of approval?
Yes.
In your opinion, will the alteration of this area and completing it, as we have shown, have any detrimental impact?
No, I don't believe so. I think it'll improve the appearance, and it will be needed to stabilize the grading that's been done.
And I assume you're familiar with the purposes of a steep slope ordinances. Does this type of work run afoul of the typical things that those types of ordinances are trying to protect against?
In my opinion, no.
That's all I have for Dave.
I have a question. Because my old eyes can't read this little plan that well. Did you add to the slope or cut the slope off? Did you steepen it or make it more gentle?
It's tough to say. I mean, I think there's probably a little bit of everything.
Looks like in places you may have cut and put a wall, like a retaining wall.
That's correct. I mean, there were some boulders, some natural boulders placed for the water feature, and then behind that, some fill was maybe added, but it was also smoothed out. So we generally still have some steeper slopes in that area, but it has been disturbed to make a smoother looking appearance than what was out there previously.
Is this going to affect the runoff of water or erosion or?
No, it'll all be stabilized with, it'll be planted landscape beds or sod.
It'll have no effect off of this property on any other property as far as water flow, concentration, or anything like that?
No, that's correct.
And it will be reviewed by the township engineer? Thank you.
Yes.
Any other questions for this witness?
I also have Mr. Orsatti here. I'm not sure we really need to have him testify. Do you think there's anything we've missed, Joe, that you need to elaborate on? He can't resist.
You brought me out here tonight.
I'll swear you in.
Do you think you need to hear more, or?
We could hear a truncated version.
Okay.
So you going to say anything
And-
exciting?
Mr. Orsatti, could you be sworn in, please?
Promise to tell the truth, the whole truth, nothing but the truth.
I do.
And say your name for the record, please.
Joseph Orsatti.
Joe, like Dave, were you involved in the original subdivision?
Yes, I was.
But then after the home got designed, you were not involved anymore?
No, that's correct.
But after this issue came up, you kind of got re-involved with it?
Correct.
Based on your experience, and I guess I jumped the gun, but you're a registered landscape architect?
Yes, I am.
And your CV is at Exhibit A9?
Yes, sir.
How many years have you been doing landscape architecture?
40 years.
Based on your experience, do you have an opinion whether these slopes are man-made?
I totally agree with Dave Gibbons. I'm very familiar with the site, having played there as a young man, filling up our canteens with water as we ran down to Skunk Hollow and Earls Lake. That slope was created when they leveled out the pad for the caretaker's cottage. They simply leveled the pad and pushed the dirt downhill.
Further away, please.
Keep the mic a little further away. hard to get the right range on those.
I understand.
And do you also agree with Mr. Gibbons that there would be no detrimental impact, some of the types of things Mr. Cutler asked about?
None whatsoever.
That's all I have for Joe.
Anybody, any questions of the board for this witness? Thank you.
I think that's all we have. We would ask that our exhibits be entered into the record.
Okay, so be it. Perhaps to generate our discussion, does anybody want to make a motion? We can then use that as the basis for discussion.
I'll make a motion to approve the application as filed.
I second it.
Okay. Is there any discussion?
I just like to state for the record, as I always do in these cases, including in your last one, that our ordinance makes absolutely no distinction between man-made and not man-made slopes, except under subsection I, which our solicitor has mentioned. So with that in mind, so no one claims any precedence being set, I think we can proceed with the vote.
Yeah, and my only comment is, and I have no reason to think that this was nothing other than a good faith mistake, but it's important for future development at this site and future development in the area that it proceed in accordance precisely with the relief granted, and if there would be any subsequent circumstances where this were repeat itself, there's a risk that the board might be less forgiving. With that being said, there's a motion which has been seconded. We'll call to a vote now. All those in favor say aye.
Aye.
Aye. No opposed. You have your relief. Thank you very much.
Thank you.
Hey, George? In this photo here,
Joe, you didn't testify that you used to ride your bike down the old Radnor Road. You remember when they changed the course?
I think the scale is a little big, but that looks a hell of a lot like an arrowhead.